Good morning. Today we are going to start with section 68. Section 68 states that whoever being in a position of authority or in a fiduciary relationship, or he is a public servant, or he is a superintendent of a jail or remand home or any other place where a woman or children are being kept, or a children institution, or on the management of a hospital, or being on the staff of a hospital. What he is doing, he is abusing his position or a fiduciary relationship, and he is inducing or seducing any woman either in his custody or under his charge in the premises to have a sexual intercourse with him, which is not amounting to rape. He will be punished with minimum 5 years, maximum 10 years and fine. Okay, now these people whom we are mentioning here in section 68, that is a position of authority, fiduciary relationship, or a public servant, or a jailer, or a manager of a remand home or the children institution, or who is an authority of a hospital. We have discussed these people beforehand also in subsection 2 of section 64. So we have to see the difference between section 64 and this section. So what is mentioned in 64 subsection 2, that these people, means the police officer, the public servant, the army people, or the staff of a jail and all, these people are committing rape. Those people are dealt in subsection 2 of 64, and they are punished by 10 years life imprisonment, that is remainder of natural life, and fine. Okay, now in section 68, these people, that is position of authority, fiduciary relationship, public servant, superintendent or manager of a jail, remand home, or the hospital authority, what they are doing, they are having sexual intercourse which is not amounting to rape. So that is the difference. Previous section, that is 64, is dealing with the offense of rape, and section 68 is telling that these people are inducing or seducing any woman, having any intercourse, but which is not a rape. Therefore it is not a rape. That is important. This is the difference between 64 and 68. Here these people are to be punished not by rape, because they have not committed rape, but they had a sexual intercourse. Therefore the punishment will be minimum 5 years, maximum 10 years and fine. Okay, now next is section 69, telling about sexual intercourse by employing deceitful means. When a person promises a woman that he will marry, and he knows that he is not going to fulfill that promise, and therefore they have a sexual intercourse, again not amounting to the offense of rape, because she has given the consent. She is feeling that they are going to get married, and afterwards he denies to marry. Then section 69 will apply, and the punishment is 10 years and fine. Here deceitful means does not mean that he will only tell or he will only give a promise to marry. Deceitful means has been defined to include inducement for a false promise of employment or a promotion or marrying, maybe by suppressing his identity also. That everything comes under deceitful means. Therefore, whoever has a sexual intercourse by deceitful means, making such a kind of false promises without intention of fulfilling the same, has a sexual intercourse which is not amounting to rape, shall be punished under section 69 by 10 years and fine. Okay, now section 70, which states about gang rape. Where a woman is raped by one or more persons, that is called as a gang rape with a common intention, then each and every person shall be deemed to have done that offense, and they are liable to be punished imprisonment minimum 20 years, maximum life imprisonment, which means remainder of natural life and fine. The fine should be just and reasonable, so that her medical expenses and rehabilitation can be done, and the amount of fine shall be paid to the victim. This is subsection 1 of section 70, telling about when a woman is being raped, a gang rape is been committed. Now subsection 2 is telling that where a woman under 18 years of age is raped, means subsection 1 is just mentioning a woman without specific age. Here it is clearly mentioned under 18 years of age. If a gang rape is been committed, then the punishment is life imprisonment, which means remainder of life, and fine or death. This is the difference between subsection 1 and subsection 2. If a girl is below 18 years, then each and every person in a gang who is committing gang rape, he will be liable for life imprisonment and fine, or death can also take place. Death can also be the punishment. Okay. The same concept is there, that the fine should be reasonable, just, which should meet the medical expenses and rehabilitation of the victim, and the amount of fine will be paid to the victim. This is section 70 telling about gang rape divided into on an age factor. Got it? Now next is section 71, that is punishment for repeat offenders, means whoever is been previously convicted for the offense under section 64, 65, 66, 70, that is relating to rape, and after subsequent to the conviction, thereafter also he commits an offense under this section, then he will be punished for life imprisonment, that means remainder of the natural life, or death. So for habitual persons committing rape or offense under this section, he will be liable for life imprisonment, or death penalty can also be his punishment. Okay. Now next is section 72 and 73. The objective of these two sections is that the identity of the victim should not be disclosed, because our society, people may harass the victim. First of all, she is harassed because of the offense being done against her, and thereafter also the society will not allow her to rehabilitate, and she will suffer. For that, section 72 and 73 is there. Section 72 is telling disclosure of identity of victim in certain offences. Whoever prints or publishes the name of the victim, he'll be liable for punishment, and the punishment is 2 years and fine. However, such a disclosure or publishing the name of the victim will not be an offense if now these exceptions are there. If the concerned victim in writing, she has told it, she has given the permission that her name can be disclosed, her identity can be disclosed, or under the order of a police officer in writing, which is essential for investigation purposes. Okay. Next is if the victim is dead, or she is a child or unsound mind. But here also the authorization of her guardian or next in kin is necessary. This is section 72. Now the last section, that is section 73, printing or publishing any matter relating to court proceeding without permission. Means if permission is taken by the court and the judicial proceedings are being published, then that is not an offense. But if without permission the proceedings are being published in the newspaper, her identity is made known to the people, then the person who publishes, the person who prints, he'll be liable to be punished, and the punishment is 2 years and fine. Whoever prints or publishes any matter in relation to any proceedings before a court with respect to an offense which is mentioned in section 72 without the previous permission of the court, means without the previous permission of the court, it is an offense, and the punishment is 2 years and fine. Mostly the offense of rape, the trial goes in camera, so the proceeding should not be published only, or if it is to be published, the permission of the court is very much necessary, otherwise it will be an offense, or it should come in the exceptions which are mentioned in section 72. The exceptions are written authorization of the victim herself, or a written authorization of the next in kin if the victim is unsound or a child, or the victim is dead, or by a written authorization by the police officer, which is this such a identification, knowing the identity of a victim is necessary for investigation purposes, then it will not be an offense. Okay, bye bye. See you in the next video.